Let's continue with our top story for tonight. The National Assembly and the National Council of Provinces have both now adopted a report recommending the amendment of Section 25 of the Constitution. Businesses, political parties and civil society held an urgent summit for organizations opposed to expropriation without compensation. Advocate Mark Oppenheimer attended that summit and he joins us now. And in fact, Mark, you were one of those that was providing legal advice to the summit delegates in terms of where to go from here on. Now, all of those people that had gathered today are opposed to land expropriation without compensation. So in terms of providing legal advice, what then becomes your starting point now that Parliament has adopted it?
There are two. So the first relates to this report that's been adopted. Now, the report is publicly available, and I think it's important that viewers read it. It's 30 pages long. One of the things that it mentions in that report is that this policy of expropriation without compensation has been tried in other countries before. It's been tried in Venezuela, it's been tried in Zimbabwe. We know that the impact was not just on those that owned land and who had it taken away from them by the state, it was on all citizens. So Zimbabwe reached the point of 90% unemployment. In Venezuela, the inflation rate has reached 837,000%. To conceptualize what that means, it is more cash efficient to use notes instead of toilet paper. Now, the committee acknowledged that and then decided to change the constitution anyway. Now, one of the challenges that can be made to that report is that it's irrational. In other words, given what this committee heard, to come up with the idea that we should change our Bill of Rights, let me say for the first time ever, this is the most sacred document that we have in South Africa. On a day when we remember Nelson Mandela, a man who fought and died for this Bill of Rights, to toss that away is a catastrophically bad idea.
But of course, counter to that, we have seen the President and other representatives of government, when speaking on international platforms, giving the guarantees that, in fact, expropriation in South Africa will be done according to the book, that it will be done to ensure that it does not have those tumultuous economic effects that you're talking about. And, you know, there's, of course, sometimes when this conversation is had, that both ends can be a bit extreme, and you know, the one end that you're speaking about now is quite extreme. So what do you then make of those guarantees that have been put by the President and others within government?
I'll say a couple of things. The first is that it will not be President Ramaphosa who implements this. When the legislature changes the law, what they do is they craft a weapon. And that is a weapon that will be used by their opponents when they lose power, and it will be used by future generations. President Ramaphosa can make no guarantees whatsoever about the impact it will have on our economy, because this will be implemented by successors. And who knows what they will do? Who knows what agendas people will resolve with this power, with this weapon? In other words, we must bear in mind as well that South Africa is governed by multiple political parties at the moment.
So then when you talk about irrationality and that being the premise on which it could potentially be opposed, are you now talking about taking it to the Constitutional Court? Where would you oppose it?
Yes, so I think there could be a number of forums that it could be opposed. It could be set aside in a review process in a High Court, or the Constitutional Court could be approached directly. Now, that's part of what could be done. The second is that we still don't know what the language of this bill will be that will change the Constitution. And it may very well be the case that that bill will itself be unconstitutional. So in Section 36 of our Constitution, we have what is called the Limitations Clause. And it says that any law that seeks to limit a right in the Bill of Rights must be justifiable in an open and democratic country that is founded on the values of freedom, dignity and equality. Now, we know that in terms of international law, states have the power to expropriate, but they have to pay adequate compensation. It's a part of customary international law. So if we change that, if we currently require just and equitable compensation, if we remove that and said that expropriation will happen with no compensation, that would not be justifiable in terms of what democratic societies do. It would be a breach of international law. We also know that Section 36 talks about less restrictive means. In other words, we might think there is something noble in intent here, which is to resolve some of the wrongs of the past. And I think all reasonable people believe that if your land was stolen from you, you should receive compensation. And we have engaged in a process since 1995 to 2014 where 1.8 million individuals have received either their land back or financial compensation for what was taken from them. And we can continue along that process.
So how much of what happens from here on is riding on the final language of that amendment?
Well, it'll be 2 parts. So firstly, from what I gather, the DA intends on launching a challenge to the report itself now that it's been adopted, and there'll be a number of challenges to that. I've mentioned already the rationality one. The other things that they can explore, the fact that a number of the submissions that were made by the public were disregarded. We do know, though, that of the submissions that were made, 65% of those submissions say don't change the Constitution.
So part of the difficulty here is that these are all issues and complaints that were heard during that land debate that was held by MPs earlier on in the week, and they went ahead and adopted the review committee anyway. So when it comes to then bringing the court back, because AfriForum went to court to try and interdict the process, the court threw it out, said in fact it was encroaching on a separation of powers. So are you not concerned that going forward you may potentially face the very same legal hurdle around the role of the legislature and the role of the executive?
Yes, so ultimately what we have is a constitutional democracy. We don't have parliamentary sovereignty anymore. So ultimately the sacred document of our constitution is what rules us all. AfriForum has started this process of legal challenge, and I think a number of others will follow in their footsteps. AfriForum's legal process, by the way, was a 2-step process. With regards to the interdict, that bit was dismissed, but they have a challenge to the report itself, and that will continue in the court process. So really what that is an opening salvo, where civil society and political parties will get together and they will fight this tooth and nail to the hilt. And it's important that they do that to protect all South Africans, because we come from a dark history where people had their land taken from them. They were not compensated, and that was wrong. And it's wrong now. And we know that the average South African thinks that this is a bad idea. When they're polled, when they produce written submissions, the majority of people are against changing the Constitution.
All right. I'm not sure about the last statement, because Parliament doesn't agree with you.
Well, in other words, Parliament has denied the fact that 65% of the written submissions that they took into account, in other words, this is in their report, are against changing the Constitution. Now, in other words, what Parliament has done is act against the will of the people. And that is after they removed over 100,000 submissions. And the suspicion is that many of those submissions were
duplicates.
Yes, the duplicate submissions.
Yeah.
Now, the duplicate submissions, this is a complicated question. So, for example, what you have is people endorsing a submission which says don't change the Constitution for all of these very good reasons. Those should be taken into account. But even if you take them out, we still have nearly 2/3 of the written submissions saying don't change the Constitution. So, and that's in the report, and that's one of the reasons why some on the committee were against the change. There's a couple of further things that must be taken into account on a substantive challenge.
All right. Unfortunately, we're going to have to leave it there for tonight. We've run out of time for the interview, but that was Advocate Mark Oppenheimer, and he's advising the collective that has come together to oppose a land expropriation without compensation.